Marketecture Live is coming up March 10th and 11th in New York City. With us, just some of the brands and agencies that have registered thus far. And don't worry, we'll be doing several of these announcements. With us, Bayer, BMO, Farmers Insurance, Electronic Arts, The Hershey Company, HP, Huntington Bank, JP Morgan Chase, Kenvue, L'Oreal, MasterCard, NFL, PayPal, PepsiCo, Redfin, Synchrony, T-Mobile, Verizon, Workday. Agencies. Want to hear which agencies are going to be joining us? Assembly, Butler Till, Canvas Worldwide, Cara, Choreograph, Credera, Dentsu, Digitas, IPG Media Brands, Magnet, OMD, PMG, Publicis Sapient, Razorfish, Wavemaker, WPP Media, and more. Can't wait to see you there. Go register now. Marketecturelive.com, March 10th and 11th.
This podcast is brought to you by AudioHook, the leading independent audio DSP. AudioHook has direct publisher integrations into all major podcast and streaming radio platforms, providing 40% more inventory than what could be accessed in omnichannel DSPs. What's more, AudioBook has full transcripts on more than 90% of all podcast inventory, enabling advanced contextual targeting and brand suitability. AudioHook is so confident that in addition to CPM buys, they offer the industry's only pay-for-performance option where brands can scale audio and podcasting with peace of mind knowing they are only paying for outcomes. Visit audiohook.com to learn more. That's audiohook.com.
Welcome to the Monopoly Report. The Monopoly Report is dedicated to chronicling and analyzing the impact of antitrust, privacy, and other regulations on the global advertising economy. I'm Alan Chapell. I'm a privacy and regulatory attorney and have worked with hundreds of digital media and ad tech companies over the years. I also publish a monthly strategic outlook report for digital media worldwide called the Chapell Regulatory Insider. You can find a link to a sample copy of the Chapell Regulatory Insider in the show notes. This week, my guest is Tom Kemp, the executive director of CalPrivacy, California's privacy enforcement agency. Previously, Tom was the founder and CEO of Centrif. Tom has served as a technology policy advisor for marketing efforts in 2020 to pass California Proposition 24, which is the California Privacy Rights Act, and advising and contributing to the passage of state privacy laws in 2023, such as the California SB 362, which is the California Delete Act, and Texas SB 2105. I'll place Tom's complete bio in the show notes. I will say that I was skeptical that California would be able to find someone to fill the very large shoes of Ashkan Soltani, who was the first CPPA executive director. But Tom was a fantastic hire and has to date filled those shoes quite capably. I know that Tom wants to talk about California's newly launched drop deletion mechanism and the privacy rights that the CCPA and the Delete Act provide to California data subjects. I am hoping to engage in a broader public policy discussion with Tom. There has certainly been a lot of activity taking place in California on privacy. I want to up-level the discussion a bit and get a better sense of the larger goals of CalPrivacy. There's lots of focus on the data broker and ad tech communities in California. I'm trying to understand how that focus and that activity are tethered to specific policy goals. So let's get to it. Hey, Tom, thanks for coming on the pod. How are you?
I'm doing great. Thanks for having me.
Well, where do we find you today?
I'm in the Bay Area, the Palo Alto Menlo Park area.
Oh, wonderful. Wonderful. I spent a lot of time out in Sausalito, and so big fan of the overall area, and particularly this time of January, because I think it is exactly 3.5 degrees here in New York City today.
We've been getting some good weather here. We've been in the low 60s. So but we understand that our colleagues on the East Coast are freezing.
So my dad had a college friend, and they were in a jazz band together, and every year they would have a beginning and end of how are we going to survive the harsh California winter party. And they had it for years and years. A whole bunch of jazz musicians would show up. It was always a good time.
It sounds like fun.
So briefly, just to set the table here, what is CalPrivacy and what is your role within CalPrivacy?
Yeah, absolutely. CalPrivacy is the nation's first and only independent agency dedicated solely to consumer privacy. It was created with the passage of Prop 24 in 2020, the California Privacy Rights Act that amended the CCPA. Now, I'm going to point out that 9.3 million people voted for that particular proposition. That's actually more than Kamala Harris got in the last election. And it is greater than the population, I think, of about 10 states in the United States. So when people say that consumers really don't want privacy, well, I think this is a great data point to show that there's overwhelming interest in having laws that give people better control over their personal information. And so this gives us, as an independent agency, responsibility in 4 areas: regulation, enforcement. And in the case of enforcement, we share that with the California Attorney General. It gives us the ability to do policy and legislation, including sponsoring bills and public affairs. So it's kind of unique in that most regulators of privacy kind of focus more on the enforcement and regulation, but we can do public affairs, we can do policy, we can sponsor legislation. And then in 2023, we were given a 5th capability, which is through the passage of SB 362, the California Delete Act. We're responsible for this accessible deletion mechanism. And then overall, I'm the executive director, so I do the day-to-day operations. I was appointed by an independent board, so I was not appointed by the governor. Oftentimes when at cocktail parties, people start complaining to me about different things having to do with California, although they don't complain about the drop system. But no, I am not a political appointee. I was appointed by a board. 2 members are actually appointed by the governor, 1 from the attorney general, 1 from the Senate pro tem leader, and 1 from the speaker. So that's how we're set up, and that's what I do on a day-to-day basis.
Okay, well, I'm curious, what were your top reasons for taking the job? And then what was it like to transition from, an investor, author, and at sometimes big tech critic into leading the biggest state's privacy regulatory agency?
Well, I've historically here in Silicon Valley been an entrepreneur and co-founded a company that went public. And then my last company, I was the founder and CEO of a cybersecurity company. So I've been in the Valley, definitely understand technology, understand the usage of personal information, historically more so from a cybersecurity perspective. And in 2020, I was a full-time volunteer on Proposition 24. It was a very small campaign. There was like 3 or 4 of us. And in effect, I was the chief marketing officer of the campaign. So I really believe in the mission of the California Privacy Protection Agency that was created. I'm going to call it CalPrivacy moving forward. That's the new consumer-friendly nickname, but our legal name is still the CPPA. But I saw the great potential of this agency. And so when this opportunity became available, I really felt I could add some unique things to the agency. Having been CEO of a company and managed over 500 people, having worked on legislation such as the California Delete Act with Senator Becker, and also proposed and worked with him on this AI Transparency Act that passed in 2024. And then also just my overall expertise in cybersecurity and privacy. So I felt it would be a good fit. And then the last reason is in 2023, I wrote an article for Tech Policy Press called Let's Make Privacy Easy. And I called for a number of things that I thought would be really good to enable privacy at scale and reduce friction. And so this was actually a great opportunity that if you write something, to be able to actually implement that vision and carry that vision over. And I'm very proud that the majority of the things that I wrote that we were able to accomplish in the last year, including successful launch of the Delete Request and Opt-out platform, getting the California Opt-Me-Out Act passed, as well as additional things that we're doing to help reduce friction for consumers being able to exercise their privacy. So it was also an opportunity to actually talk the talk, but walk the walk and have things that I care about be able to be implemented.
Well, I'd love to post the article in the show notes. And also, I would love to know, Of the topics that you talked about in the article, is there anything in there that you still sort of on your list?
The answer is yes. And so we're actually addressing that right now via both policy in the form of regulations as well as proposed legislation. So the article, it was having for third-party data an accessible deletion mechanism, which is the drop system. The second focus area in the article was to have the ability to have opt-out preference signals for first-party data to enable do not sell shares. The third area was reducing friction for consumers. And what we're doing now is actually going to come out with and gather feedback on regulations to do exactly that. Are there additional things that we can do with consumers to not only enable operationalizing privacy rights, but also make it easier for businesses at the same time to respond to requests from consumers as well? Furthermore, today we, with Senator Becker, we're announcing a new bill called the Expanding Privacy Rights Act, where we further enhance the ability for consumers to make privacy requests, as well as expanding the deletion rights that consumers have with first-party interactions. And we can talk a little bit more about that bill maybe later. But yes, so have really kind of hit two of the three. And then the third one is in process, both with regulations and legislation.
Well, fantastic. You guys have certainly been pretty busy, to say the least. I wanted to talk a little bit about the drop mechanism. So I want to give it its full name with the delete, request, and opt-out platform. We're going to go with drop from here on in. But it went live on January 1. And so what is the drop? You sort of alluded to it, but what does it do? How has the initial rollout performed? And what has the early adoption been?
Yeah, so the drop system is a free online tool developed by CalPrivacy. We partnered with the California Department of Technology, or CDT, to help build that. And it launched January 1st of this year. It was required by the California Delete Act, which was SB 362, authored by Senator Becker and signed into law by Governor Gavin Newsom in 2023. Now, I want to be very clear. This is not an original idea. Senator Wyden had some proposals, 5, 6, 7 years ago. Tim Cook, the CEO of Apple, wrote a editorial in Time Magazine in 2019 calling for a data broker clearinghouse. And then there has been a federal proposal by Senator Cassidy, obviously a Republican, Senator Ossoff, a Democrat, called the Delete Act, which is the federal version. And in 2022, I talked to Senator Becker about this. I proposed this to him, and he loved the idea and he proposed it. And it's really the world's first platform of its kind. It makes it very easy for Californians to be able to exercise their privacy rights at scale and better protect their personal information. And so what Californians do is they go to this website on privacy.ca.gov/drop. They verify their residency, put some basic information in, and then that information is immediately stored in a secure manner. And then starting in August, data brokers that have registered with the state, and as of December 31st, there was over 545 data brokers that register, will have to consult the system and then actually hash their own information. And then if there's any matches, then they're going to have to delete and create a suppression list for if they subsequently get the information as well. And so late breaking news here, besides telling you about today's announcement about the Expanding Privacy Rights Act that's being announced in an hour from when we're recording this. So probably by the time this gets published, it will be publicly out. But the other late breaking news that you'll be the first to know is that we've hit over 200,000 Californians that have signed up for the drop system. That's pretty amazing because it's only launched in just 28, 30 days ago. So we're now seeing over 50,000 Californians a week sign up for the system. And I think that really, again, just like Prop 24 overwhelmingly passed, this is a great data point that Californians or just consumers in general want more privacy protections. And so we're very grateful and gratified. And I should point out that this was fully funded through data broker registrations to access fees. This is not taxpayer dollars paying for this. So it's a free service that people could take advantage of. It doesn't really kick in until the fall when the deletions occur. But even with that, people are signing up in droves.
Do you have a guesstimate for what percentage of the California population you think is going to ultimately sign up for this?
I do have some internal guesstimates, but we're not actually publishing those as well. And the interesting thing is that we haven't done any marketing per se for this. This has all been organic. And we also kind of felt that because the deletions would not occur until the fall and that's per statute, and I'm perfectly fine with that. We fully need to get the data brokers to register. The registration ends January 31st. We are going to make available the API this spring and have people test things out. So there should be a lag between when people can sign up and when the deletions occur. So we want to make sure data brokers are all in line and able to successfully test things out before using that. But it was pretty amazing, frankly, to see that even though the deletions won't occur for 7, 8, 9 months down the road, that people still just want to get in line, still want to use the system, et cetera. And one last thing I'll bring up about the drop system. It's a living, breathing system that if consumers add a phone number, an email address, they figure out how to what their mate is, or they want to they get a new car and add a VIN, they can go back and add that stuff. And then similarly, when the deletion process begins, they can go back and consult the system and see what the status of the deletions and what data brokers have deleted their information, what data brokers said, oh, this data is exempt, what data brokers have said no match. And inside the system, if they're not happy, and if they think that a data broker says that they haven't deleted, but they have some evidence that the data actually is still out there, they can file a complaint directly with us inside the system as well. So it's a nice closed loop system that Californians can come back to enhance their information, check their status, and if they have an issue that they can raise a complaint with us.
Well, for what it's worth, what I'm hearing from friends in California, and I'm going to exclude, my tech friends and my legal friends, my lawyer friends, there seems to be a fair amount of buzz, if that's really the right word here, amongst people who I would not necessarily have expected to know about this. So it's going to be really interesting to see ultimately what the adoption is, because it's still early, but it does seem like the initial signs point to something that's pretty robust.
Yeah, what we've heard from journalists and people in media, that when they've posted articles or interviews on this topic, that this is one of the more popular pieces of content that they've posted. And so I think that there's just a lot of desire and a lot of frustration out there. We always talk about the privacy paradox. And the privacy paradox is that people talk the talk about privacy, but they don't walk the walk as it relates to actually exercising their privacy. My thesis, which goes back to that article I talked about, Let's Make Privacy Easy, is that it's just the reason why there hasn't been greater adoption of and usage of privacy tools is that they've been too tough. They've been too hard, right? And it's very difficult to enable that at scale. I mean, compare the alternative of not having drop, that you would have to reach out to 545 data brokers, spend 20, 30 minutes kind of going back and forth with each and every one. So multiply 30 minutes times 545, and it's not a permanent deletion. So 545 times 20, 30 minutes is 10 days of work to be able to submit requests. And so the nice thing is that this is kind of one of the first steps that we're trying to do to enable privacy at scale and kind of tip the balance back to consumers in terms of giving them the tools that they want. And so people do want tools, but you got to make it easy for them. And if you do make it easy, people will exercise. And you saw that with Prop 24 with 9.3 million votes. You saw that with the tracking transparency, that there's very high adoption. I know you have a lot of thoughts on that, ATT from Apple, but we all can agree that a lot of people have turned that on. And then now you can also see that with initial deployment metrics associated with the drop system here in California.
Yeah, I'm not sure I would use ATT as the bastion of demonstrating how much consumers care about privacy. I think it has as much to do with, consumers, if you scare them enough, they're going to take a certain action.
Okay, then we'll throw that out and it's just simply point to that there was an opportunity in 2020 to enhance the California Consumer Privacy Act. People did vote overwhelmingly for that, 9.3 million voters. And as it relates to the drop system, we have seen, overwhelming demand.
We talked about this a little bit before we jumped on. I mean, there is certainly a lot of interest from even other states. And I think, as you know, I had Senator James Maroney on the pod and a couple of other state lawmakers recently, and they've indicated some initial interest and maybe even some discussion about leveraging the drop to varying degrees. I'm curious if you're in position to maybe add some additional color around some of those discussions.
Absolutely. Thank you for asking about that. I mean, I'm not going to share the specifics of the conversations, but generally speaking, it's very safe to say that there's been over 10 states that have expressed interest in doing legislation to rein in data brokers, if not more. And right now, we do have data broker registration laws in California, Oregon, Texas, and Vermont. And there are a number of states, either their governors or politicians, that have publicly considered and proposed the Delete Act type legislation, including in Vermont, Nebraska, Illinois, just heard about Virginia, and then the governor of New York expressed interest in this as well. So there's definitely a pain point. There's an itch that needs to be scratched here. And I think, this is another example of California setting the pace for consumer protections and having other states follow. This has been true for over 100 years. That first started with food safety, then you got auto emission standards and automobile safety. California was the first state to have a data breach law. And of course, California was the first state to have a comprehensive privacy law. And now I think people are looking at California with a bit of envy and seeing that, hey, this Delete Act is something that consumers really want. So we are certainly interested in discussing with other states how we can help them to implement a Delete Act type style system like our drop system. Now, one unique thing about our privacy law, which was the California Privacy Rights Act, Prop 24, that amended the CCPA, is that it explicitly gives us and it tells us that the agency should go out and work with other states, work with local legislators, as well as other jurisdictions on privacy. And we will. So we are having conversations with other states about not only what the text should be, but also, like how one would go about implementing this. And, from our perspective, helping other states adopt similar privacy measures will only cement the rights that we have here in California and make them stronger. And I think that's why that was built into the actual statute itself with Prop 24.
So I may be reading into this a little bit, but it sounds like the discussions are a little bit more around, hey, we've built something pretty cool and we can provide some high level guidance on how you might want to build something equally cool, rather than, hey, we've built something pretty cool, we'll license it or figure out how to add other states to the larger mechanism. Closer to the former than the latter?
No, I think everything's on the table.
Is that something that CalPrivacy could initiate it on its own, or would you need some form of authorization to include other states?
Well, we report to an independent board, so the board would have to approve that. So that would actually be, public knowledge out there. And the board has actually expressed interest in doing that. And so to the extent of additional approval that would be needed or required, it really depends on the proposals that they get there. But we're open to all forms of cooperation with other states. And I want to point out that this is not just blue states, it's red states. We are, again, I mentioned I'm not a political appointee. We are an independent agency, and we work closely with, Republicans here in California as well as Democrats. And likewise, just doesn't matter if it's Texas or it's, Vermont or, other states out there. In fact, we're also engaging with this organization that we helped set up called the Consortium of Privacy Regulators. And now I think it's at 10 or 11 different states are involved. And we even have Indiana, which is a red state, participating in this. So there's just a strong desire out there for cooperation. We're having these conversations. Everything's on the table in terms of specifically as it relates to the DELETE Act. And so if we get to the point where there's a concrete proposal, a memorandum of understanding, we will bring it forth to the board and have them weigh in on this. So we're open for any conversations to the extent of providing guidance to sharing technology in some form or fashion.
Well, that's fantastic. And collectively, with I think California taking the lead, you were stepping into what I think is a very clear void, for better or worse, left by the federal government. So I want to shift gears a little bit with your permission and talk a bit about privacy harms. And I will confess that my thinking on this has evolved pretty significantly, where I used to be a little bit more skeptical about, we'll call ethereal harms. I'm almost air quoting here. Or harms to dignity. But over the past few years, where there are serious risks to the right of assembly and using location data to aid law enforcement efforts, that said, in an ad setting, outside of precise location, what privacy harms are you most concerned about, and what impact do you think those harms have on Californians?
Yeah. No, I mean, we are concerned about the misuse or failure to protect sensitive personal information such as health, geolocation, et cetera. For example, we just came out with an enforcement action against a data broker, and they allegedly, first saying that they didn't have any Californians data, and we were able to show that on their website there was a spreadsheet where you could download with people with California, but they were also selling lists of people with Alzheimer's and other medical conditions. And so that was a great deal of concern. And so the good news is part of this settlement that they have exited the California market. And so at least through this data broker, you can't sell sensitive information such as if you have Alzheimer's. And I understand there could be valid reasons, and there are valid reasons for that, for having lists such as that for medical testing and all that stuff.
Right, but I want to get outside of health and location, because most of my audience is really in the ad space. And so I wanted to better understand, how are you thinking about harms within that space outside of precise location and health?
Okay. I mean, obviously, we're also looking at things in terms of, vulnerable members of our community, such as elderly and children who are not in a position to protect themselves. So what we've been doing from an enforcement perspective is really just trying to make sure that it's easy for consumers to be able to exercise their privacy rights. And if you look at the enforcement actions that we have been doing, we've been just trying to build building blocks of saying, look, that a business has been asking for too much information for a consumer to exercise their rights, that they haven't been supporting the global privacy control, and they've been, in effect, kind of providing dark patterns as well. And so once we get kind of that baseline understanding and building blocks from an enforcement perspective, we certainly look to focus even more on specific issues regarding kids' data, as well as better protecting the elderly. So what we're trying to do is try to focus on concerns that reflect kind of the fears of average Californians that we serve. And, the key thing of that is to facilitate that is that we want to make sure that people are not blocked or there's any roadblocks or hurdles in their ability to exercise their rights. And so we're really trying to make privacy rights easy to exercise. That we've seen that with the drop system, and then also through legislation, the California Opt Me Out Act, that provides that switch as well. So in some sense, we kind of have to build the base, the framework to facilitate that. But then, from there, you will be seeing specific enforcement actions involving specific vulnerable communities that we think that need better protection.
So, and what I'm hearing, and I just want to give you an opportunity to clarify, what I'm hearing is a focus on rights more so than a focus on addressing specific harms. Again, outside of, you've got health, you've got elderly, you've got kids, and you've got precise location, I suppose. But it seems to be the focus is, at least initially, is on granting certain rights and less on the harms.
Well, I mean, clearly we did harms as it relates to some of the enforcement actions in the sensitive areas. But yes, I mean, you got to build kind of building blocks in terms of enforcement actions, in terms of enforcement advisories. And so once you kind of level set right there and kind of provide a baseline and clear expectations, then there's the ability to kind of then target specific harms affecting vulnerable members of our community. And I think you will be seeing more, specific areas that affect kids, elderly, et cetera, coming from the agency. But we just have to kind of build up to that point to make sure that there's a level playing field as it relates to the ability to exercise rights.
No, and fair enough. And I would say, for whatever this is worth, in my view, the approach to enforcement thus far has been rather measured and seemingly fair. You've gone after very specific things. And so kudos. I mean, because the tendency with a new agency could be to come down and just start raining lightning bolts randomly on the marketplace. And you guys have clearly not taken that approach, and you should be given some credit for that.
We're trying to set expectations. That's why when we do come up with the enforcement actions, that we clearly spell out what the issues are. That's why we come out with enforcement advisories. That's why we announce investigatory sweeps as well. So we're telegraphing exactly kind of the areas of focus. And so I think and then attorneys do a very good job of doing write-ups. And so everyone kind of knows, as you said, we certainly don't want to we want to make sure that expectations are properly set. And the expectation that we're clearly sending to people is that you do not put burdens and too many hoops in front of consumers to enable the exercising of their privacy rights. And we're giving kind of building block examples through enforcement actions, through enforcement advisories, et cetera, to kind of level set. So look, at the end of the day, our being an entrepreneur, we like clear in a past life, we like clear guidance. We're trying to provide clear guidance to businesses and setting expectations. We do want to enable operationalization of privacy rights, but we also want to make sure that our regulations, our law, our advisories can easily operationalize by businesses. And so we're trying to strike that balance between innovation and privacy rights as spelled out in the California Privacy Rights Act, Prop 24, that clearly said that as well. And so we're just trying to make sure that, we're doing the proper level setting across the board.
So I want to shift again, and we talked a bit about the drop. You have alluded to, or maybe discussed a little bit, some of the online, the opt-out preference signals, the oopses. And I will note that the drop and the opt-out preference signals, I don't like calling it an oops. I don't know why. But the drop and the oops together serve a similar role as is currently provided by authorized agents. And how do you see those two roles developing over time? I mean, is there going to be room for authorized agents down the line?
Opt-out, I mean, the one thing that, as we mentioned before, with opt-out preference signals, we were able to sponsor a piece of legislation, which was the California Opt-Me Out Act, which was Assemblymember Lowenthal. That was AB 566 that does require web browsers to have that global privacy control setting, which we call, here in California, called the opt-out preference signal, built in. To your point, that does enable privacy at scale. In the case of the drop system, that's focused on third-party data. In the case of OOPS and GPC, that's focused on first parties that consumers interact with and sending the signal to do not sell or share. Now, specific to your question about authorized agents, and do they kind of fill a role or are they analogous? I will say that authorized agents are actually mentioned, I think, about 3 or 4 times in the CPRA, the Proposition 24, and they enable the consumer to exercise all their privacy rights. So in the case of the drop system, that's more focused on a certain set of businesses and specifically around deletions and opt-out. In the case of opt-out preference signal, that's for first-party relationships with businesses, and that's focused on just simply do not sell shares. authorized agents are much broader, as you probably know, that they can facilitate exercising of all rights. And it's not just limited to certain types of businesses. It facilitates the ability to exercise rights on behalf of consumers for all businesses as well. And I think that the reason why the author of the CPRA, which was Alistair McTaggart, who I know well, that he felt that authorized agents are an important option for consumers, as there are many people out there that don't have the wherewithal or expertise to exercise their rights. For example, elderly parents or judges or elected officials who may be threatened, who may face, having to do something in a short period of time, and they don't have the time or the bandwidth or the expertise to do that. Or the reality is that in the current opt-out mechanism, that the average consumer doesn't have the time to chase down hundreds or thousands of different businesses and say, opt me out. So
but that's sort of my point, though, Tom, is that the authorized agents seem to fit the same role as the deletion mechanism. No?
Yeah. So from my perspective, what opt-out preference signal does, as well as a drop system combined, raises the floor, right? And it does provide, kind of analogous capabilities. But what I'm trying to say is that it's not that there's still a very high ceiling up there, and there probably should exist an ecosystem of authorized agents. Now, the ecosystem of those type of authorized agents may not necessarily be third-party businesses. It may eventually evolve to we have AI agents working on our behalf, maybe built into the phone or browser, kind of as you go about your day-to-day thing. They may tap you on the shoulder or may do things on your behalf as well. So the point is the law clearly allows for that, and it allows for the exercising of rights for all your rights as well as for all types of businesses. But California, the legislature, because it was the legislature that built on top of this Lego block of the CCPA as amended by CPR. They added the Delete Act on top of it. They added the Opt Me Out Act on top of that. Said, okay, we like the rights that are available. We like the fact that authorized agents are enabled, but we need to raise the floor up because there's a lot of pain out there as it relates to consumers exercising privacy at scale. So if your thesis is drop and the global privacy control as implemented as OOPS here in California represents kind of a means and mechanism analogous to authorized agents, I agree with that thesis, but I also don't want to say that just doing drop and GPC is the end all or be all. I think what we'll see in the market is further evolution. You could even argue that these kind of commoditize certain aspects of the pre-existing authorized agent market by raising the floor. But I still think that there's a lot of headroom out there. I don't know how that's going to be, but I do think there is a need out there, especially for entities and people that just don't have the expertise to do that. And eventually that may just be a set of AI agents that work on our behalf.
Okay, so that's helpful. I have a follow-up question, and it's sort of a similar question with respect to authorized agents and browser-based implementation of GPC signals. In the case of browser-based GPC signals, is California considering something that would, similar to Connecticut, where you would implement some flavor of anti-preferencing measures? And this sort of gets back to what we were talking about with ATT. Apple has built a $16 billion ads business ever since ATT came on the scene. And so if a browser is basically saying that, company X, what you're doing is a sale or a share, but our ad product is not, that would seem like a conflict of interest, right? And I'm just curious if the CalPrivacy folks are thinking along those lines around setting up that type of anti-preferencing measure.
Well, we did, at the last board meeting, we set forth 4 areas of possible new regulations. It was approved by the board, one of which is streamlining privacy notices. Another one was better handling employee data. The third was better facilitating the exercise of privacy rights. And the fourth one was any additional regulations specific to the opt-out preference signal in light of the passage of the Opt Me Out Act. So we are going to actually get public comment. We've already gotten a letter from, I know you're affiliated with the NAI, and we appreciate public comment on that. We haven't formally kicked off the public comment process on that. So I don't want to comment on that because that's something that we are going to first internally investigate. Then we're going to go out and get public comment and feedback on it as well. And we know that people have already brought that to our attention as well. So I don't want to put my thumb on the scale because I want to hear from all parties as it relates to, is there additional regulations that we need in this area? And hear from the public, hear from industry, hear from civil society groups. So, so I think that is going to be something that will be discussed, and we've made it public that we're going to open it up and have regulations. And at the next board meeting in February, we're going to give a timeline for when people can participate in this process with us, and we'll go through that.
Well, that's great to hear. And I'm glad to hear that there's a commitment to a thorough investigation of some of those underlying issues. Apple and Google have attempted to block the requirement to have the global privacy control in their browsers. I mean, it was going to be passed by Governor Newsom a year ago, and my understanding is that there was a pretty robust lobbying effort to make sure that doesn't happen. So I'm glad to hear that issue will at least be on the table for consideration. I want to ask a similar question with respect to authorized agents, because I've said this, and I want to say it to you because I've sort of said it on previous pods. It feels like California has sort of unleashed this concept of authorized agents, and I'm curious if there's going to be some regulation around what good and bad practices for authorized agents are, because I can tell you that there's companies out there who are misrepresenting the law and are essentially cluster bombing ad tech companies with requests, which I just don't think is helpful. I've said this publicly, so I just wanted to get your reaction. Is that something that you guys can commit to taking a look at?
Well, as I mentioned before, authorized agents are built into the law, that they were explicitly called out in the California Privacy Rights Act, which was Prop 24. Furthermore, we've come up with regulations that actually have some regulations as it relates to authorized agents. And one of the new areas of regulations I mentioned before, which is reducing friction for people to exercise, we will look at if there's additional things that need to be done as it relates to authorized agents. But I think going back to the statute, the actual law, which was, again, approved by the voters. So it's not Tom Kemp's opinion, that it's in the law that there was a belief that there should be authorized agents to help facilitate for consumers, because it's very difficult in today's data economy, with all the different websites, mobile apps that people interact with, that there is a need to provide assistance, much like there is a need out there for people to have help with their taxes, right? So it's built into the legislature.
I'm not disagreeing with you that it's in the law, and I'm not disagreeing with you that there's a need. Where I think there might be a slight point of disagreement is on the degree that model should be regulated going forward.
It is regulated. We do have regulations, and as I just said, that we potentially will look at that and as part of the reducing friction. And I've also been very clear that we do want to not only have the ability for consumers to operationalize the exercise of privacy rights, but I've also been very clear that we want to make sure that businesses can operationalize their obligations under California law and regulations. And so I very explicitly said that one of the 4 areas of new regulation beyond the opt-out preference signal, beyond employee data, and streamlining privacy notices is exercising of privacy rights, which would include potentially, based on feedback that we get from industry, et cetera, is there additional things that we have to do as it relates to authorized agents. So it's on the table, and we look forward to investigating this as well. So.
Well, good. And I appreciate that. And I take you at your word that there's going to be at least some mention of that, or there's going to be some ability to provide feedback. Because I think there are some things that industry could do that would be much, much better and more transparent for consumers. For example, there is currently no requirement that they list the data brokers that they are protecting one from. And that seems like a baseline transparency requirement. No?
Yeah, I mean, you're trying to kind of work the ref before the game's even started on this. So I've made it quite clear that we're going to...
The game started several years ago, Tom. They exist.
In terms of the actual we're coming out with a set of new regulations, and we want to get people's feedback. And I appreciate you guys providing this. And so you should definitely, your listeners and anyone else, we certainly want to hear from you, and we understand that we want to make it operationalized on not only for consumers, but also for businesses as well. So we're opening it up to like, how can we reduce friction out there? And I said that there's an ability to also, provide content and feedback as it relates to authorized agents. And so we're opening this up. We're visiting this again. And I don't know what else I can say. That we're going to look at this. So
great. No, I appreciate that. And I'm glad to hear that there's going to be continued examination. So you have mentioned that CalPrivacy will target companies that, I'm going to use air quotes here, walk and talk like a data broker, even if they don't claim that title. And I'm curious, how are you thinking about drawing that line, particularly with respect to companies operating in the digital media space?
We have to follow the statute, and there is a definition of data broker. And then oftentimes that if there's some vagueness, then we go through with a given term or expression like direct relationship. Then we go through the regulatory process, and the regulatory process is, we get the public feedback, and then we talk, we debate. And by the way, I have had so many, besides civil society groups and meeting directly with consumers, I've been to a number of senior citizen meetings and hearing what they've said, but I also meet with industry as well. So it's complete open door. And to your point, I think you mentioned before we started that there could be, we can agree to disagree as well. So we went through that process to define, what a direct relationship is, regulations as well. So we're just going to implement what the law and the regulations have to say. And so the law is very clear, defining what a data broker is, and then we provided additional clarification as it relates to direct relationship. And so the goal is that, we will fairly, look at any entities that are acting like a data broker under the law. We hope that they actually do register. And the registration ends tomorrow. And so I don't know if this podcast is going to go out tomorrow, but
but by the time this comes out, it's going to be too late. And if I were you and you fit the definition of data broker, boy, register tomorrow if you can.
Yeah, please, absolutely. If we can kind of go in the past. So yeah, no, look, we're following the statute. And again, we've been bent over backwards. Like we even came out with an enforcement advisory about, data broker and registration. We came out with that a month or two just to further help if people have subsidiaries that are doing certain type of things. So absolutely, we're just going to follow the law here. And this reflects the will of the legislature. And of course, our actual underlying privacy law reflects the will of the voters. And so our goal is to fairly, enforce, these laws.
So I'm curious, do you see like retailers registering? Because a lot of them are using third-party marketing profiles and using them off of their digital properties.
Yeah, we've been very clear that if you may have a first-party relationship, but then you start supplementing that with third-party data, and then you turn around and sell that third-party data, then you actually fall under as a data broker. And then if a delete request comes in, you'll have to delete the third-party information, but retain the first party. It makes perfect sense. Just because you collect someone's email address and then you use the email address to completely supplement it with all this other third-party information, and then you sell it, right? Then you're acting as a data broker. And so then if then when you register and the drop request comes in, you can still retain the email address that you got, but you have to get rid of the third-party data that you were acting as a data broker with. So it's very clear, from that perspective. So I don't know if it's specific a retailer or whoever it is, but it's clearly defined.
What about a company like Palantir? I mean, do you see them registering?
I'm not allowed to, and I won't specifically call out, look at X, look at Y, look at Z, is this company, a data broker, et cetera. We're just going to go based on what the law and the regulations say. And I don't know in detail, what their business practices are. And I just hope that, people, follow the law. And if it turns out that they're not, then we have shown our ability to go out and aggressively enforce not only the registration, but I want to point out that just because you don't register doesn't get you off the hook with the fines that will happen come August, which is $200 per day per incident. So hopefully that is a big motivator that, you can't like wave your hands and say, oh, I'm going to not file the paperwork, et cetera. Well, no, actually, you will get dinged for the fines right there, which most companies can afford them. Most of our fines have been $40,000, $50,000, $60,000. Although in some cases, we actually, as part of the enforcement action, we shut down a business, a data broker. And in the case of a more recent one, that they agreed to not participate in the California market. So oftentimes the enforcement also has other aspects associated with it. But come this fall, that irrespective if you register or not, if you're not doing the deletions, it's $200 per day per consumer record that matches in your system.
And that adds up pretty quickly.
Very much so. So please register if you think you're a data broker.
So, Tom, this has been an absolutely fantastic discussion. I really appreciate you coming on. I know that I've sometimes asked what might be characterized as difficult questions, but this has been really helpful for me, and I'm sure for my audience to better understand. Before I let you go, though, I want to clarify one thing, and because I may have misheard you. With respect to OOPS's, like the global privacy control, that isn't just a first party signal. That's a third party in the old ad tech way of saying like that impacts, third parties as defined under California law as well. No?
Well, I don't know. It's hard for me to give legal interpretation. I don't know what the interaction is as well, but clearly it's because it's a browser plugin and you're sending the signal to the actual businesses that you're interacting with. So if there's that interaction and businesses can receive the signal, therefore they should do that. And again, we fully understand that now we're moving to AI and agentic browsers, that there could be even further confusion on this. And so that's why we also have said, again, we want to make sure businesses can operationalize this, that we're going to provide we're going to do research. We're going to get feedback to do further clarification of the actual, opt-out preference signal, especially because we will see significantly enhanced adoption when come January 1st under the Opt-Me-Out Act, that all browsers will have to provide that as a switch that consumers can take advantage of. Yeah, so it's kind of hard for me because people start asking me, well, what about this company or what about this scenario? I don't know. And I just would certainly just hope people would do the due diligence out there as well. And to the extent that we need to provide further clarification, we want that feedback as part of the regulatory process. So even before we put pen to paper, we're going to have sessions that people can write us letters, or maybe even open sessions that people can call in and tell us what's that. At the same time, I want to be very clear to your audience. I meet with everyone. And so I'm more than happy if people want to have a further discussion on this. And that's why I went on your podcast, because I know your audience is a great audience right here. I want to make sure that we're open to listening and hearing what's going on. And we understand that there may be things that may not be working from an operationalized perspective. We certainly want to know about it, because we want to make our privacy not only easy for consumers, but we want to make it as easy as possible for businesses, because we firmly believe in what the statute said, which is we want to balance innovation with guardrails, and that's kind of having come from a business background and coming from the tech industry. I'm 100% supportive of guardrails, but let's not give businesses busy work as well. And if there needs to be areas of clarification, that's why we're going through this feedback process that we will announce in a couple of weeks in February, where people can send us letters or contact me, and we can set up phone calls. More than happy to do that.
Well, fantastic. I really appreciate that. And I sure appreciate you coming on. Tom Kemp, where can people find you and CalPrivacy?
Yeah, so obviously go to privacy.ca.gov, and that's kind of our new main website. We do have a cppa.ca.gov website. That's actually another late breaking news. We're going to be merging that into the privacy, and we're going to, instead of having two sites, we're going to have one site, and it's going to be the privacy.ca.gov website. So just go there. And we provide not only the drop system, but we provide privacy tips. And, check it out and, reach out if you want to have a further conversation with us. More than happy to engage with people.
Well, fantastic. And that comes across very loud and clear here, and I sure appreciate it. Tom Kemp, thank you so much.
Hey, thanks a lot for having me.
I really appreciated this discussion. We've gotten some great guests to come onto the podcast over the past year. And I think the reason people come here is to talk about difficult topics involving complex trade-offs. So here are my thoughts after my discussion with Tom Kemp. First, on privacy harms, when I pressed Tom about what specific harms CalPrivacy is focused on in the digital ad space, outside of health data, precise location, and vulnerable populations, the answer kept circling back to rights enforcement rather than demonstrable harms. Now, I understand the need to establish baseline compliance, but if we're going to regulate an entire industry and spend a non-trivial amount of resources doing it, it's helpful to be crystal clear about what problems we're solving. This all ties into my comments on last week's podcast with David Leduc that none of the big tech companies are registered as data brokers in California. And it's the reason I asked today whether Palantir was a data broker. California has made a series of policy choices regarding the rule set they are creating. And personally, I think it's important to make sure that all of this is aligned with concrete privacy harms. I recognize that others may see things a bit differently. Second, on browser preferencing, Tom acknowledged that CalPrivacy is at least open to putting browser anti-preferencing measures similar to those provided by Connecticut on California's agenda. I hope they make good on that promise, because I think it's a problem for browsers to treat their own advertising products differently than third-party ad services when implementing GPC signals. This is a critical issue, even more so given that Tom referenced the idea of providing even more power to browsers as authorized agents under California law. Here's some additional context. We are no longer in the era where a browser is solely a user's agent. Companies like Perplexity clearly view their browser as a piece of software they can use to monetize. And even Apple has built a $16 billion advertising business after implementing App Tracking Transparency, a system that treats Apple's ad products differently from third-party ad products. Competition regulators in Europe are viewing ATT as anti-competitive, and I think it would be a shame if California didn't, at the very least, have these competitive issues squarely on the table for public discussion. And finally, on authorized agents, Tom made an interesting comment that the drop and GPC, as implemented as an opt-out preference signal, commoditizes the authorized agent business as of today, at least with respect to deletion and opt-out requests. It will be interesting to see what happens if more states adopt their own drop mechanisms. As of today, more authorized agents are focused on deletion requests. And there may be less of a market for those types of services in the upcoming years, given that California is looking to offer those services for free. Tom repeatedly pointed to the fact that authorized agents are, quote, in the law and currently regulated. But being in the law doesn't mean the current framework is working. As I said, some authorized agents are misrepresenting the law, bombarding companies with questionable requests, and operating without basic transparency principles, like disclosing which data brokers they're actually protecting consumers from. To his credit, Tom said that CalPrivacy will look at these issues. I hope they do more than look, because this needs real attention. As I told Tom today, I give CalPrivacy credit for taking a measured approach to enforcement to date. And the enforcement does seem to be focusing on areas where consumers are actually being harmed. The drop deletion mechanism is genuinely innovative, and the early adoption numbers suggest real consumer demand. I do hope CalPrivacy keeps a public tally of how many Californians avail themselves of the drop mechanism. But as this agency matures, it needs to move beyond process and focus a bit more on outcomes. Are the rules being applied fairly across all players? And are we creating a system that protects consumers from something tangible? In any event, it was a great discussion, and I hope was not the last time that Tom and his colleagues visit this podcast. We've got a bunch of other fantastic guests coming up on the Monopoly Report podcast over the next few weeks. Please subscribe to the show at monopolyreportpod.com or on Spotify, Apple, YouTube, or wherever you listen to your podcasts. And thanks for listening.